Students, we are looking into the various problems with regard to the Mohemmadan law. Today, let us see very interesting problem under modern law concerning to the live-in relationship. Probably you have heard what is this live-in relationship and what is the stand of the Supreme Court with regard to the live-in relationship. That means if a man and woman they live together for a considerable length of time, they will be considered as husband and wife. So that is the stand of the Supreme Court with regard to the present status. But here we have to see this aspect from the background of what you call the personal law. Here with regard to the Hindu personal law, according to section 114 of the Evidence Act and according to the recommendations of the Justice Mohemmadan Committee, a woman who lives with the man for a considerable length of time, she will be called as the wife and she is eligible to get all the benefits as a legitimate wife. So that is the recommendation, and there are so many case laws are there. Case laws of with regard to the parties who are Hindus. So that we can see with regard to the personal law of Hindu and with regard to the personal law of Muslims. What is the status of live-in relationship? Here probably you know that with regard to the personal law of Hindus, there is a legislation is there, Hindu Marriage Act of 1955. Whereas with regard to the Muslims, majority of their personal aspects, except very few legislations, all their personal matters concerning to the marriage, with regard to the divorce, with regard to the waqf, gift, all those things will be guided by the Islamic personal law. So today let us see what is the status of Islam with regard to what is the stand of Islam with regard to the live-in relationship. And I have told you what is the problem today we are going to discuss with regard to today's topic, and I need not have to tell you with regard to these steps. Here these FIRAC means facts. In Kannada it can be called as Sangati. Issue it will be called as Vivadamsha. Rule it will be called as Niyama. Analysis it will be called as Visleshane. Conclusion it will be called as Tirmana. So in this way we have to solve the problems under these five groups. Here there are other things are there, IRAC, ILAC, all these things are there, but we are following only this method, that is FIRAC. Here this has been taken from this problem has been taken from the previous question paper under the KSLU. Here we have to look into this problem. We can look these things with regard to these things we can see by considering the problem. Here, how to solve this problem? That means here with regard to the living relationship, how the Mohemmadan law it will speak with regard to what is the stand we can see with regard to the aspect of living relationship. Here the problem is that Sania and Suhail are close friends. That means they belong to the same community, that is Islamic community. They do not have any legal impediments to marry each other. That means there are no obstacles with regard to the marrying with each other, because as you know there are so many the sub-sects are there. There are so many the aspects are there. Shia, Sunni, all those things are there. Here there is no impediment, there is no problem with regard to the marrying of Sania and Suhail, and they decided to live together without undergoing the formalities of marriage. That means they don't want to get into the marriage contract. Otherwise they want to live together. That means in India it is fast growing. That means everywhere in the entire world this aspect is fast growing. And what happened? They decided to live together, and after getting a child, their relationship was strained. That means they lived together, and they had a baby out of their relationship. Later, the relationship between Sania and Suhail has become strained, means it has been worsened. So now Sania is looking for a remedy advice. That means now we have to advise Sania with regard to the what is the legal remedy is available under the Islamic law. So we have to advise the Sania. That means now I think you have understood the problem. What is the problem you have understood? ವಿದ್ಯಾರ್ಥಿಗಳೇ, ಇದರಲ್ಲಿ ಸಾನಿಯಾ ಮತ್ತು ಸುಹೇಲ್ ಆಪ್ತ ಸ್ನೇಹಿತರು ಅವರ ಮಧ್ಯೆ ವಿವಾಹ ಆಗಲು ಕಾನೂನುಬದ್ಧ ಅಡಚಣೆಗಳು ಇರಲಿಲ್ಲ. ವಿವಾಹ ಔಪಚಾರಿಕತೆಗಳನ್ನು ಪಾಲಿಸದೆ ಇಬ್ಬರು ಒಂದಾಗಿ ಬಾಳಲು ನಿರ್ಧರಿಸಿದರು. ಮಗುವನ್ನು ಪಡೆದ ಬಳಿಕ ಅವರ ಸಂಬಂಧ ಬಿರುಕುಗೊಂಡಿತು. ಈಗ ಸಾನಿಯಾ ಪರಿಹಾರವನ್ನ ಹರಿಸುತ್ತಿದ್ದಾಳೆ ಸಲಹೆ ನೀಡಿ. ಅಂದ್ರೆ ಇದು ಯಾವ್ದ್ರ ಬಗ್ಗೆ ಹೇಳುತ್ತಂದ್ರೆ ಒಂದು ಲಿವ್ ಇನ್ ರಿಲೇಶನ್ಶಿಪ್ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ. ಅಂದ್ರೆ ಮದುವೆ ಆಗದೆ ಒಂದು ಒಟ್ಟಾಗಿರೋವರ ಒಂದು ಅವರಿಗೆ ಅವರ ನಡುವೆ ಯಾವ ಸಂಬಂಧ ಇರುತ್ತೆ, ಮತ್ತೆ ನಂತರ ಅವರಿಗೆ ಹುಟ್ಟಿರೋ ಮಗುವಿನ ಒಂದು ಅದರ ಸ್ಟೇಟಸ್ ಏನು, ಅದರ ಒಂದು ಏನು ಕಾನೂನಿನ ಸ್ಥಾನಮಾನ ಏನು, ಧರ್ಮಜನ ಅಧರ್ಮಜನ, ಆಕೆಗೆ ನಾನು ಮೇಂಟೈನ್ ಸಿಗುತ್ತಾ, ಅದರ ಬಗ್ಗೆ ನಾವು ಸಲಹೆಯನ್ನ ನೀಡಬೇಕು. ಹಿಯರ್ ಲೆಟ್ ಅಸ್ ಡಿಸ್ಕಸ್ ದಿಸ್ ಪ್ರಾಬ್ಲಮ್ with regard to the following steps. Here in this way we can divide the steps. That means in this way we can divide the facts. Sonia and Suhail are best friends. They decided to live in relationship without marriage. No obstacle for their marriage. They get a child out of living relationship. Their relationship got strained. So in this way we can simplify the facts. That means if we simplify the facts, then it will be very much easier for us to solve the problem. Probably with regard to the English grammar, there is a we have to reduce the passage, we have to increase the passage, likewise there. So if some passage will be given, we have to answer the questions. Likewise here some problem will be given, we have to simplify it, then we will get some some issue. So when we see the facts, we will find certain issue. You can see what is there in Kannada. In Kannada it has been translated with regard to the given problem. So here with regard to this aspect, you can frame, as I told you, with regard to any problem. That is problem is with regard to any issue, with regard to any problem. That means suppose you happen to become advocate or happen to become judges, happen to practice practice in the field of law, then you have to know what is the problem between the plaintiff and defendant, and then in civil cases you have to frame the issues. So in the criminal cases there are charges will be framed, that is different. With regard to the civil case, the issues has to be framed. So for the salvation of that the issue between the plaintiff and defendant, the issue has to be framed. So here you can frame any number of issues, but it should be concerning to the problem. Here the issue is will come up in this way: whether Sania is justified in live-in relationship without marriage as per Muslim personal law. So this is the first issue, because there was no impediment for them to get married, but they opted for the live-in relationship. Whether it has been justified in the Muslim personal law, whether it has been justified in the Muslim personal law. And next issue is whether Sania can get remedy in live-in relationship without marriage under any other law. So with regard to if the answer is no for the first issue, if the answer is no with regard to the first issue, then we have to go for the second issue. ಅಂದ್ರೆ ಇಲ್ಲಿ ಏನಪ್ಪಾ ನೋಡ್ತಾ ಇದೆ ಅಂದ್ರೆ, ಇಲ್ಲಿ ನಾವು ವಿವಾದಾಂಶವನ್ನು ನಾವು ಅದನ್ನ ಬರಿಬೇಕಾಗುತ್ತದೆ. ಇದರಲ್ಲೇನಿದೆ ವಿವಾದಾಂಶ? ಮುಸ್ಲಿಂ ವೈಯಕ್ತಿಕ ಕಾನೂನಿನ ಪ್ರಕಾರ ವಿವಾಹವಿಲ್ಲದೆ ಒಂದು ಲಿವ್ ಇನ್ ರಿಲೇಶನ್ಶಿಪ್ ಹೊಂದಿದ್ದರೆ ಸಾನಿಯಾ ಸಮರ್ಥನೆ ಆಗುತ್ತಾಳೆಯೇ? ಅದರಲ್ಲಿ ಒಂದು ಉತ್ತರ ಇಲ್ಲ ಅಂತ ಬಂದ್ರೆ, ಆ ಸಮಯದಲ್ಲಿ ಸಾನಿಯಾ ಅವರು ಬೇರೆ ಯಾವುದೇ ಕಾನೂನಿನ ಅಡಿಯಲ್ಲಿ ವಿವಾಹವಿಲ್ಲದೆ ಲೈವ್ ಇನ್ ರಿಲೇಶನ್ಶಿಪ್ ಸಂಬಂಧದಲ್ಲಿ ಪರಿಹಾರವನ್ನ ಪಡೆಯಬಹುದೇ. So in this way there are two issues has been framed with regard to the problem which has been discussed earlier. Here with regard to the issues, I think you have followed with regard to how the issues has to be framed, and with regard to how we should simplify the facts. Then we can go for the provision of law. So what are all the provisions will be applicable? So what are the provisions will be applicable with regard to the given the case? What are all the rules of law will be applicable with regard to the instant case? So that we have to see. Here the provision of law is live-in relationship in Islam is haram. That means this sort of the live-in relationship in Islam is prohibited. That means it will be called as haram. That is, it is against to law, it is against to society, and it is not invited, because this live-in relationship it has been followed from the Western culture. It's not the Indian culture or the Islamic culture. So here this live-in relationship in Islam, it has not been considered, and it has been said as it is haram. And here now we have seen that with regard to this aspect, live-in relationship, Islam strictly prohibits this sort of the relationship. And with regard to the Article 21 of the Constitution of India, you know what the Article 21 which will speak, that is right to live with dignity. That will speak with regard to the personal liberty of the citizen, or now even in case of the non-citizen also it will be applicable. That is that is right to live, that is right to life. That means this is live-in relationship will also come under the Article 21 of the Constitution of India. And next one is 114 of the Evidence Act also it will be applicable. Next one is section 125 of the CRPC will also be applicable with regard to this what you call the given problem, because section 125 of the CRPC, you know, it will speak with regard to the maintenance given to the wife. So here with regard to the recent what you call the developments in the law, with regard to recommendations of the Mohemmadan committee, and with regard to the so many that decided case laws. So given the woman, she lives in the live-in relationship, she will be considered as a wife. She will be entitled to get the what you call the maintenance. So these are all the things we can see. But one more thing we have to know, that means with regard to what about the custody of the child. That means they have got the child. So here we are advising what are all the things will be concerning to the woman. But what about the custody of the child? There is one aspect is there in that means with regard to the woman. That means she is entitled to get the custody of the child. That is izanat. So under izanat, a woman, a married woman, she will get the what you call custody of the child. But with regard to with regard to any child whose mother, she will get the custody of the child. So that aspect we can say with regard to the provision of law, that is rule of law. That means we have to discuss here what is the Islamic law, what is there in the Article 21 of the Constitution of India. We have to see the Evidence Act, we have to see the section 125 of the CRPC. That means here it requires the broad knowledge. That means certain questions will be like this in Mohemmadan law, certain questions will come like this, because as you know, the personal law for Mohammedans, it will speak with regard to certain things, but certain matters we have to follow some what you call universally applicable law. Universally applicable law means that is CRPC, CPC, and the contract, special contracts, and all those the laws, legislated enactments we have to follow when there is a when there is a what you call ambiguity, when there is ambiguity in the what you call application of the Islamic law with regard to any problem. So there are certain law, Muslim wife dissolution marriage act is also there. Likewise, certain acts are there. So here that's why now in the Constitution of India also there is one provision is there, that is a uniformity of civil code. That means if uniformity of civil code has been applied in entire India, then there is no problem with regard to the application of some common civil code to all the ಪೀಪಲ್ ಆಫ್ ಎನಿ ರಿಲಿಜಿಯನ್. ಅಂದರೆ ನಾನು ಏನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂದರೆ, ಇಲ್ಲಿ ಪ್ರೊವಿಷನ್ ಆಫ್ ಲಾ ಅಂದರೆ ರೂಲ್ ಆಫ್ ಲಾ ಅಂದರೆ ಯಾವ ಕಾನೂನಿನ ನಿಯಮ ಅನ್ವಯ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದರೆ ನಾವು ಇದರ ಬಗ್ಗೆ ಬರೀಬೇಕು. ಯಾವುದರಲ್ಲಿ? ಒಂದು ಇಸ್ಲಾಂ ಕಾನೂನಲ್ಲಿ ಇದನ್ನ ಹರಾಮ್ ಅಂತ ಕರೀತಾರೆ, ಅದನ್ನ ಲೈವ್ ಇನ್ ಸಂಬಂಧವನ್ನ ಹರಾಮ್ ಅಂತ ಕರೀತಾರೆ, ಅಂದ್ರೆ ಅದರಲ್ಲಿ ನಿಷೇಧ ಮಾಡಿದ್ದಾರೆ. ಮತ್ತೆ ಇದಕ್ಕೆ ನಾವು ಸಂಬಂಧಪಟ್ಟಂತೆ ಭಾರತ ಸಂವಿಧಾನದ 21ನೇ ವಿಧಿಯನ್ನ ಸಹ ನೋಡಬೇಕು, ಮತ್ತೆ 114 ಒಂದು ಸಾಕ್ಷ್ಯ ಕಾಯ್ದೆಯನ್ನ ನೋಡಬೇಕು, ಮತ್ತೆ 125 CRPC ಕಲಮನ್ನ ನೋಡಬೇಕು. ಅಂದ್ರೆ ಇಲ್ಲಿ ಭಾರತ ಸಂವಿಧಾನ 21ನೇ ವಿಧಿ ಯಾವುದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದೆ ಅಂದ್ರೆ ಒಂದು ಜೀವಿಸುವ ಹಕ್ಕು. ಅಂದ್ರೆ ಇಲ್ಲಿ ಲೈವ್ ಇನ್ ಸಂಬಂಧ ಒಂದು ಜೀವಿಸುವ ಹಕ್ಕಿನ ಅಡಿಯಲ್ಲಿ ಬರುತ್ತೆ. ಆದ್ರಿಂದ ಇದನ್ನ ಭಾರತ ಸಂವಿಧಾನದ 21ನೇ ವಿಧಿ ಮೂಲಭೂತ ಹಕ್ಕುಗಳಲ್ಲಿ ಇದನ್ನ ನೋಡಲಾಗುತ್ತದೆ. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ನಿಮ್ಗೆ ಮಹಮ್ಮದೀಯರ ಕಾನೂನಲ್ಲಿ ಹೆಚ್ಚಾಗಿ ಈ ತರ ಒಂದು ಸಮಸ್ಯೆಗಳು ಬರಲ್ಲ. ಎಲ್ಲ ಅಲ್ಲಿ ಒಂದು ಮಹಮ್ಮದೀಯರ ಕಾನೂನಲ್ಲಿ ಯಾವ್ದ ವಿಷಯವನ್ನು ಹೇಳಿದ್ರೆ ಅದರ ಬಗ್ಗೆನೇ ಬರುತ್ತೆ. ಕೆಲವೊಂದು ಸಮಯದಲ್ಲಿ ಈ ರೀತಿಯ ಸಹ ಬರುತ್ತೆ, ಕೆಲವೊಂದು ಸಮಯದಲ್ಲಿ ಈ ರೀತಿಯ ಒಂದು ಸಮಸ್ಯೆಗಳು ಸಹ ಬರಬಹುದು. ಇದಕ್ಕೆ ಏನು ಮಾಡ್ಬೇಕಂದ್ರೆ, ನೀವು ನಿಮ್ಮ ಜ್ಞಾನ ಭಂಡಾರವನ್ನ ಹೆಚ್ಚು ಮಾಡ್ಕೋಬೇಕು. You have to study what you call, you should know the legal concepts. That means these are all the common legal concepts here, that you should not think that this Constitution of India and this Evidence Act, CRPC, we have not studied. Here certain common tenements will be there, common principles which you should know. That means if you have got the interest, definitely you will come to know. That means here the journey of the student is like a researcher. ಅಂದ್ರೆ ಒಬ್ಬ ವಿದ್ಯಾರ್ಥಿಯ ಒಂದು ಕಾನೂನಿನ ಅಧ್ಯಯನ ಯಾವ ರೀತಿ ಇರ್ಬೇಕಂದ್ರೆ, ಅದು ಒಂದು ಒಬ್ಬ ವಿಜ್ಞಾನಿಯ ತರ ಇರ್ಬೇಕು. ಅಂದ್ರೆ ಆತ ಹೊಸದಾಗಿ ಅನ್ವೇಷಣೆಗಳನ್ನ ಮಾಡ್ಬೇಕು. ಅಂದ್ರೆ ಇವಾಗ ನಮ್ಮ ವಿದ್ಯಾರ್ಥಿಗಳು ಕೆಲವೊಬ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಯಾವ್ದೋ ನೋಟ್ಸ್, ಯಾವ್ದೋ ಒಂದು ಇದು ಆ ಕ್ವಶನ್ಗೆ ಅದು ಆನ್ಸರ್ ಬರ್ದ್ಬಿಟ್ರೆ ಸಾಕಂತಾರೆ. ಆ ರೀತಿಯಲ್ಲಿ ಇಲ್ಲ. ಈಗ ಬರ್ತಾ ನೀವು ಏನಂದ್ರೆ ಒಂದು ಅನ್ವೇಷಣೆಯ ರೀತಿಯಲ್ಲಿ ನೀವು ಅದನ್ನ ಬೆಳೆಸ್ಕೋಬೇಕು, ನೀವು ಆಸಕ್ತಿನ ಬೆಳೆಸ್ಕೋಬೇಕು. ಆಗ ಮಾತ್ರ ನಿಮ್ಗೆ ಒಂದು ಜಯ ಸಿಗುತ್ತೆ. ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಈ ರೀತಿಯ ಒಂದು ಸಮಸ್ಯೆಗಳು ಕೊಟ್ಟಾಗ ನೀವು ಬರೆಯೋದಕ್ಕೆ ಕಷ್ಟ ಸಾಧ್ಯ ಆಗುತ್ತದೆ. Then we have to go for the analysis. Here in analysis we have to write everything with regard to the premarital aspect and what is there in the Islamic text. Here premarital sexual relationship with which Islamic texts prohibit, but Islam does not forbid love. That means here the Islam does not forbid the love, but it will prohibit the premarital sexual relationship. That's why in Islam it has been provided to undergo the nikah. That is a nikah. It is a contractual marriage. That means it is like if they give consent, if they like each other, then only they can go get into married. They get into marriage. So these things we can see with regard to the Islamic law. Here dating is also called as halal. That means in Islamic law, this dating, that is live-in relationship, and aspects concerning to this live-in relationship, that is dating, that is mostly widely practiced in present day, is prohibited. It is called as halal in Islamic law. Although in practice some may choose to cohabit according to according to Muslim teachings, it is wrong. Muslims believe that for a couple to live together in a sexual relationship, they must be married first. So any cohabitation without marriage is sinful, and children born out of such bondage do not get the legitimate status. So when their relationship does not have the approval from the personal law, how we can expect the children will get the legitimate status? So under Muslim law, there is the live-in relationship has not been recognized, and if any children born out of that bondage will not get the legitimate status. So this is the analysis we have to make, and here we have to analyze these aspects also, these facts and what you call issue. These facts we have to analyze, issue we have to analyze, and the provision of law we have to analyze, and we have to write the analysis. Then we can go for the conclusion. Here the ultimate thing what we have to write the conclusion with regard to any problem. Here we should not be very much hurry in addressing the conclusion first. We have to write something with regard to the provision of law, rule of law, issues, analysis. Then we can go for the conclusion. You can simplify it. Here, if it is for lesser mass, you can simplify. There is no need of writing the very detailed answers. Here, that's why I am covering all the aspects. So here, as far as possible, if it is for 6 marks, if you write the what is the what you call rule of law, what is the issue, how and how you are going to analyze the things in 1 or 2 sentences, it's okay, but it should be legally justified. And conclusion is that Sania do not get any relief under the Mohemmadan law. That means out of this discussion we can say that Sania do not get any relief under Mohemmadan law. Under Muslim law, there is no obligation as such to maintain the child born out of live-in relationship. So there is no obligation under the Islamic law with regard to the maintaining the children who born out of this live-in relationship. That's why now the status of the live-in relationship children, they are very miserable. Now they could not able to the father and mother, they will not rear the children, because that's why these children will be given in adoption. So that is the present what we call practice in India. But however, we can see with regard to the present problem here the Sania that means here no parent has got the has to maintain the child born out of such relationship, but the mother will have all the rights under the Muslim law is known as hisanat, and it could be used against the father of the child or any other individual. That means if mother wants to rear the child or brought up the child, she has got the better right rather than the person who is responsible for the birth of that child. And as per here with regard to the Muslim law, no rights at all for the Sania. And as per section 125 of the CRPC, the section includes provision for all children who cannot claim remedies in their laws. That means here with regard to the present status of the section 125 of the CRPC, where the children who cannot claim remedies in their laws means in their personal laws or any laws, that is LAWS laws. This at that time, then they can get the relief. There are no specific personal laws governing this relationship, but under section as per one section 125 of the CRPC, the section includes provision for all children who cannot claim remedies in their laws. That means under section 125 CRPC, with regard to which aspect it will deal? It will deal with regard to the maintenance. It may be maintenance of children, it may be maintenance of wife, or it may be maintenance of the father and mother. So this is the aspect we can see. That means it has been widely we can find the connotation of the section 125 of the CRPC. ಅಂದ್ರೆ ಈ ಕಲಂ 125 CRPC ಅಂದ್ರೆ ದಂಡ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆ, ಅಂದ್ರೆ ಭಾರತೀಯ ದಂಡ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆ ಪ್ರಕಾರ ಯಾವ ಮಕ್ಕಳಿಗೆ ತಮ್ಮ ಕಾನೂನುಗಳಲ್ಲಿ ಪರಿಹಾರಗಳನ್ನ ಪಡೆಯಲು ಸಾಧ್ಯವಿಲ್ಲ ಅಂತ ಮಕ್ಕಳಿಗೆ ಏನೋ ಒಂದು ಯಾವುದೋ ಅಂತ ಒಂದು ಮಕ್ಕಳಿಗೆ ಒಂದು ಪರಿಹಾರವನ್ನ ಈ ಕಲಂನ ಅಡಿಯಲ್ಲಿ ನೀಡಲಾಗಿದೆ. ಅಂದ್ರೆ ಯಾವುದೋ ಇಸ್ಲಾಮಿನ ಕಾನೂನಿನಲ್ಲಿ ಅವರಿಗೆ ಪರಿಹಾರವಿಲ್ಲ, ಅಂದ್ರೆ ಈ ಕಲಂ 125 ಪ್ರಕಾರ ಇಂಥ ಮಕ್ಕಳು ಯಾವುದೋ ಒಂದು ಲಿವ್ ಇನ್ ರಿಲೇಶನ್ಶಿಪ್ ಇಂದ ಹುಟ್ಟಿದ ಮಕ್ಕಳಿಗೆ ಒಂದು ಪರಿಹಾರವನ್ನ ನೀಡಲಾಗುತ್ತದೆ, ಮತ್ತೆ ಮಹಿಳೆಗೂ ಸಹ ಇದರಲ್ಲಿ ಪರಿಹಾರವನ್ನ ನೀಡಲಾಗುತ್ತದೆ. So this is with regard to the problem with regard to the live-in relationship is the very beautiful the problem which we can see in modern days. So you should have the what you call the effectiveness, and you should be legally competent to solve the problems in this way. So in the next video, let us analyze the other problems with regard to the Mohemmadan law.